Hello, my name is Matthew Scott. I'm head of the People on the Move thematic area at the Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Lund, Sweden. It's my pleasure to share some reflections on the implications of the decision of the Human Rights Committee in the case of Teitiota against New Zealand. I think the most significant element of the decision of the committee lies in its interpretation of the non-refoulement obligation under Article 6 of the International Covenant on Civil and Political Rights. Earlier interpretations of how this article applies in the context of non-refoulement emphasized the need to establish a risk of dying in the immediate context of return to the country of origin or habitual residence. So that follows from the wording of the article, which talks about the arbitrary deprivation of life. And this kind of an interpretation is what the New Zealand Immigration and Protection Tribunal, as well as higher courts in New Zealand, applied in Mr. Teitiota's case before it reached the Human Rights Committee. What the Human Rights Committee did was to apply a broader interpretation of Article 6 that it had earlier developed in its general comment number 36 on the right to life, which developed a concept of the right to life with dignity. Now, when the committee applied this concept of the right to life with dignity to a situation where the non-refoulement obligation was being invoked, it was invited to consider a far broader range of circumstances beyond the real risk of dying in the context of return to the country of origin or habitual residence. What the court considered was the potential adverse impacts of disasters and climate change on access to food, access to water and shelter, as well as the highest attainable standard of health. And what that means is that in deciding cases where individuals seek to invoke the non-refoulement obligation, decision makers need to think about a broad range of economic, social, and cultural rights, which significantly expands the scope of consideration beyond what previously might have been limited to a question of the real risk of dying in the country of origin or habitual residence. So the committee is quite clear that the non-refoulement obligation can arise well before there is a real risk of dying on return. And there's a qualitative assessment of the point at which a person may be said to no longer enjoy the right to life with dignity in the country of origin or habitual residence. Now, in Mr. Teitiota's case, the tribunal found, or rather the Human Rights Committee, found that that threshold had not been met and may not be met for some time in the context of a small island developing state like Kiribati. But what's interesting from an international law perspective is how this principle of the right to life with dignity may apply in other claims for international protection brought by people from other countries in the world that are also facing significant adversity in the context of disasters and climate change. And in this context, it's important, and I'd like to mention, the significant numbers of claims for international protection that we're starting to see being brought by people who are already experiencing disaster-related displacement and other adversity that arises in the context of climate change. Research that's being conducted by the Ludwig Boltzmann Institute of Human Rights in Vienna, together with the Raoul Wallenberg Institute in Sweden, is looking at judicial decisions in both of those countries and can report that hundreds in the case of Sweden and thousands in the case of Austria, we can report those numbers of individuals who have brought claims for international protection, relying specifically on adverse environmental conditions that they fear being exposed to on return. Taking those cases together with emerging evidence of similar claims in the German context suggests that this decision of the Human Rights Committee in Teitiota against New Zealand warrants close consideration by lawyers who may be representing individuals seeking international protection, as well as by judges whose duty it is to apply international law in these kinds of cases. So the jurisprudence can be expected to continue to develop, and it's important that we keep up to date with the latest thinking from the committee. Thank you.